Great honor for me to introduce Brian Leiter, that currently has a chair in law in the Chicago University. Professor Leiter works in the Philosophy, Human Rights and Values Center. Between 1995 and 2008, he taught at the University of Texas, Austin. He is also a philosopher belonging to the Princeton University, and he has a degree in law from the Michigan University, where he also took a doctoral course. He also was publisher of Legal Theory magazine, and he is currently a co-publisher of the series Oxford Studies in the Philosophy of Law, together with Professor Leslie Green from Oxford University. He has taught masterclasses in York University in Canada, in Geneva, and in the Mississippi University. His book, Legal Theory, Naturalizing Jurisprudence, represents an intellectual shift very important in the law philosophy history. Professor Leiter proposes to reconstruct the legal realism to the epistemological premises of the famous naturalist philosopher Quine. His thoughts are characterized by the denial of the possibility of a merely analytical and conceptual knowledge. The central argument is that we need to form our concepts on the grounds of empirical methods belonging to science. According to Leiter, this has been the intellectual task of the legal realism. In the meta-ethics fields, Professor Leiter tries to show and prove the possibility of a modest possibility of legal facts, which is important for the liberal project. But among his interests, we find not only the reflection on the essence of law and jurisprudence, he has also formulated very important interpretations of Nietzsche's work in the light of a naturalist methodology. Leiter's work is very wide and deep. Among some of his most read and quoted articles, we can mention the following: Determination, Objectivity and Authority, Rethinking Legal Realism, Nietzsche and the Morality Critics, and Beyond the Hard and Working Debate. Today, Professor Leiter will present an article entitled The Demarcation Problem in Jurisprudence, a new case for skepticism. I just give him the floor.
Very nice introduction. I hate to disappoint the Spanish speakers. I'm going to speak in English since I don't have any Spanish. I do want to thank Jordi Ferrer for organizing this, and Carmen Vasquez for handling all the logistical issues that arose in getting here. This is a wonderful event, and I'm very pleased to be here. So, for more than 200 years, legal philosophers have been preoccupied with specifying the differences between two systems of normative guidance that are omnipresent in all modern societies: law and morality. In the last 100 years, what I will refer to as the demarcation problem, the problem of how to distinguish these two normative systems, has been the dominant problem in jurisprudence, and legal positivism has offered the most important solution. Positivists such as Kelsen, Hart, and Raz claim that the legal validity of a norm cannot depend on its being morally valid, either in all or at least some possible legal systems. And the range of the scope operator here marks the distinction between hard and soft versions of positivism. Kelsen tells us on the first page of the Pure Theory that the theory, quote, attempts to answer the question what and how the law is, not how it ought to be. And the second chapter on law and morals sets out to establish that the science of law, the science of the legal validity of norms, is not to be confused with ethics, the science of the social norms denominated moral. Law and morals must be recognized as different kinds of normative systems, Kelsen says. A difference he locates in the fact that law involves a socially organized coercive sanction, while morals lack such sanctions, substituting, and I quote again, merely the approval of the norm-conforming and the disapproval of the norm-opposing behavior. The first sentence of the concept of law states Hart's aim to, quote, further the understanding of law, coercion, and morality as different but related phenomena. He famously identifies as one of the three main issues driving jurisprudential inquiry the question, how does legal obligation differ from, and how is it related to moral obligation? That issue looms so large because, as he says, law and morals share a vocabulary, so that there are both legal and moral obligations, duties and rights, and all legal municipal systems reproduce the substance of certain fundamental moral requirements. This, of course, leads positivism's most important competitor, natural law theory, to claim, this is Hart's characterization, that law is best understood as a branch of morality or justice. Positivists, of course, deny this. Finally, and as is well known, Hart devotes an entire chapter of the concept of law to the relationship between law and morals, noting that positivists deny that the criteria of legal validity of particular laws used in a legal system must include tacitly, if not explicitly, a reference to morality or justice, and that in consequence, and I quote again, it is in no sense a necessary truth that laws reproduce or satisfy certain demands of morality, though in fact they have often done so. Now, Raz similarly devotes fully half of his classic collection of essays, The Authority of Law, to criticizing various attempts to establish a conceptual connection between law and morality. And the seminal chapter on legal positivism and the sources of law makes clear that the identification of law, quote, is a matter of social fact that is independent of its moral merit. So if it is familiar and uncontroversial that the demarcation problem has been central to legal philosophy, it perhaps requires more emphasis what kind of answer to the demarcation problem jurisprudence have demanded. Hart himself says we want to understand, quote, the nature or the essence of law. But what is it to understand the nature or the essence of law? Julie Dixon, following Raz, says that, and here I quote from Dixon's 2001 book, a successful theory of law is a theory which consists of propositions about the law which, one, are necessarily true, and two, adequately explain the nature of law. I am using the nature of law, she says, to refer to those essential properties which a given set of phenomena must exhibit in order to be law. Dixon is echoed more recently by Scott Shapiro, who says that inquiring into the fundamental nature of law, we want to, quote, supply the set of properties that make possible or actual instances of law the things that they are, and he offers the example of water being H2O, I quote, being H2O is what makes water water. With respect to law, accordingly, to answer the question, what is law on this interpretation, is to discover what makes all and only instances of law, and not something else. In addition, says Shapiro, and here again echoing Dixon, who I take to be following Raz, and I quote, to discover the law's nature is also to discover the necessary properties, that is, those properties that law could not fail to have. Legal philosophy has, unsurprisingly, always been hostage to its philosophical climate. Jurisprudents are rarely, if ever, innovators in philosophy. They instead are the jurisprudential owls of Minerva, bringing considered philosophical opinion in its maturity, sometimes, alas, on its deathbed, to bear on theoretical questions that arise distinctively in the legal realm. Thus, Kelson's jurisprudence bears the stamp of neo-Kantianism and the moral anti-realism common among logical positivists, while Hart's jurisprudence reflects the methodological influence of ordinary language philosophy and the substantive influence of post-World War II Oxford-style non-cognitivism. Kelson and Hart had, in my view, the correct metaethical views, but did not perhaps fully appreciate their import with respect to their central jurisprudential concerns. What is particularly striking is that even at the dawn of the 21st century, legal philosophers set conditions for a successful analysis of the demarcation problem, namely to identify the necessary and essential properties of law that distinguish it from morality and other normative systems. They set conditions for a successful analysis that would strike most philosophers in other fields even 30 years ago as wholly incredible. The persistence of the demarcation problem means the jurisprudential owl of Minerva has not yet taken flight. I hope here to set this venerable philosophical bird on her path and to lay the demarcation problem to rest. So the concept of law is an artifact concept. That is, a concept that picks out a phenomenon that owes its existence to human activities. It is, that is, an artifact of those activities. Even John Finnis, our leading natural law theorist, does not deny this point. I certainly do not understand Kelson, Hart, Raz, Dixon, or Shapiro to deny this claim. Those who might want to deny that law is an artifact concept are not my concern here. The extravagance of their metaphysical commitments would be subjects for psychological, not philosophical investigation. Artifact concepts, even simple ones like chair, are notoriously resistant to analyses in terms of their essential attributes, both because they are hostage to human ends and purposes and because they cannot be individuated by their natural properties, unlike, say, natural phenomena like water, which I agree just is H2O. Chairs can be made of stone or wood or metal. Their apparent function, providing support for those who sit, can be discharged by boxes, tortoises, car seats, and steps. Moreover, some chairs have as their actual function ornamental decoration, not sitting. Some serve primarily as shelves for stacking papers or books. Some chairs have armrests, some do not. Some have backrests, some do not. Because human ends and purposes shift, the concept of a chair has no essential attributes. Now, the question of whether an artifact concept has an extension that can be picked out in terms of necessary and essential properties is not one unfamiliar to 20th century philosophy. Far from it. Karl Popper, Rudolf Carnap, and Karl Hempel, to name three luminaries of 20th century philosophy, were interested in a version of the demarcation problem. Not how to demarcate law from morality, to be sure, but how to demarcate epistemically reliable forms of inquiry from epistemically unreliable ones. That is, how to demarcate science from pseudoscience or nonsense. Like the legal philosophers, they sought to identify the essential properties of a human artifact, namely science. They failed, and spectacularly so. Perhaps there is a lesson for legal philosophers in this story. In philosophy of science, the demarcation problem was the problem of figuring out which kinds of human inquiry were epistemically special. That is, which had epistemic properties or characteristics that warranted the inference that the conclusions of such inquiry were likely to be true. Those epistemically special forms of inquiry were to be deemed scientific and so deserving of credence, while all others were not. Permit me to quote from Larry Loudon's seminal treatment of the rise and fall of the demarcation problem in philosophy of science, which he characterizes as follows. This is Loudon. We expect a demarcation criterion to identify the epistemic or methodological features which mark off scientific beliefs from unscientific ones. We want to know what, if anything, is special about the knowledge claims and the modes of inquiry of the sciences. Any philosophically interesting demarcative device must distinguish scientific and non-scientific matters in a way which exhibits a surer epistemic warrant or evidential ground for science than non-science. If it should happen that there is no such warrant, then the demarcation between science and non-science would turn out to be of little or no philosophic significance. Attempts to solve the demarcation problem were, in turn, precisely efforts to specify the conditions which are both necessary and sufficient for some form of inquiry to be scientific. The history of the search for such a criterion is quite a long one, going back to antiquity, though the artifact concept Aristotle wanted to understand is different from ours, not surprisingly. In the 19th century, there were attempts to specify the distinctive method of scientific inquiry, but the solutions to the scientific demarcation problem most familiar to us now were those associated with the logical positivists and Karl Popper. Verificationist theories, this is on the logical positivist side, verificationist theories held that scientific propositions were genuinely meaningful, that is, empirically verifiable. These theories, however, ran into trouble because, on the one hand, as Loudon observes, many statements in the sciences are not open to exhaustive verification, for example, all universal laws, while many false statements, like the earth is flat, are verifiable, though false, since, as Loudon notes, we can specify a class of possible observations which would verify the statement. Popper's alternative, eschewing verification for falsifiability, ran into different problems. It could not explain the scientific status of most singular existential statements. For example, there exists a black hole is not falsifiable. And it deems scientific and thus epistemically reliable this is Loudon, every crank claim which makes ascertainably false assertions. As Loudon observes, we cannot prove that there is no conceivable philosophical reconstruction of our intuitive distinction between the scientific and the non-scientific, or we might add, between the legal and the moral. But we can conclude, as Loudon does, that none of the criteria which have been offered thus far promises to explicate the distinction. We should therefore ask, according to Loudon, why solving the demarcation problem matters. For what philosophical or practical purposes do we need a solution to the demarcation problem? In the case of science, the solution mattered for explicitly practical reasons. As Loudon puts it, demarcation criteria are typically used as machines de guerre in a polemical battle between rival camps. So, for example, this is Loudon's characterization again, Popper was out to get Marx and Freud by showing that their theories were not falsifiable. It is now notorious that Popper had no grasp of either Marx's or Freud's views, but that is not a dispute we need to resolve here. What matters, as Loudon notes, is that the labeling of a certain activity as scientific or unscientific has social and political ramifications which go well beyond the taxonomic task of sorting beliefs into two piles. Precisely because a demarcation criterion will serve as a rationale for taking a number of practical actions which may well have far-reaching moral, social, and economic consequences, it would be wise to insist that the arguments in favor of any demarcation criterion we intend to take seriously should be especially compelling. That's Loudon. In other words, the demarcation problem was thought to matter because knowledge matters, because what we know affects what we think ought to be done. As Loudon remarks, it remains as important as it ever was to ask questions like, when is a claim well confirmed? When can we regard a theory as well tested? What characterizes cognitive progress? What the failure in philosophy of science to solve the demarcation problem shows is that we cannot take a shortcut to answer these questions by simply dividing forms of inquiry into the scientific and non-scientific based on some necessary and essential properties distinguishing the two forms of inquiry. So what then about the demarcation problem in jurisprudence? I do not need to rehearse for this audience the doubts about the positivist analysis of law, the most powerful and successful analysis of law we have. Many of these doubts may be, as I am inclined to think, misguided, yet who can deny that there are genuinely hard cases for the positivists to explain? I'll focus on Hart's version for purposes of exposition. Hart says that the, quote, necessary and sufficient conditions for a legal system require that citizens generally obey the valid primary rules and that the officials of the system accept the secondary rules of the system from an internal point of view. That is, they view them as imposing obligations upon them. Can there not then be a legal system in which the officials are motivated by merely self-interested concerns? For example, they enforce the secondary rules because it advances their professional career or spares them from political retribution. I take it Hart is committed to denying that. The question is, why? Can the idea of a rule of recognition really account for the reasoning of common law courts interpreting precedents? Another standard worry about Hart's version. Hart says the rule of recognition is merely a social rule, so its content is fixed by whatever the practice of officials in a particular legal system happens to be. Raz says the practice cannot include appeal to moral criteria of legal validity consistent with the law's claim to authority. Shapiro says it cannot include such appeals consistent with the law's claim to guide conduct. Wallachow argues the law's claim to authority is compatible with an official practice of employing moral criteria of legal validity if authoritative directives are merely weighty rather than exclusionary reasons for action, and so on. If in the history of philosophy there is not a single successful analysis of the necessary or essential properties of a human artifact, why should we think law will be different? If hundreds, perhaps thousands of philosophers in the last century, both the innovators like Carnap and Popper and the legions of less well-known philosophical laborers could not specify the essential and necessary features of science, perhaps the most important and transformative human artifact of recorded history, should we really hold out hope that an analysis of law will yield necessary and essential criteria? A skeptical induction over past failure is not a conclusive refutation. Just as the failure to solve the demarcation problem in philosophy of science does not prove that there is no account of the essential and necessary properties of an inquiry that is scientific. But rather than belabor the no doubt familiar disputes about the demarcation problem in jurisprudence, let us follow Loudon's lead and ask a different question. Namely, why does solving the problem matter? In surveying the writings of the great writers on the demarcation problem in jurisprudence, I here mean mainly Kelsen, Hart, and Raz, it seems that two practical concerns explain the importance for these writers and those who follow them of demarcating legal from moral norms. First, the fact that a norm is legally valid does not mean it is morally obligatory. And second, the fact that a decision by a legal official would be morally attractive does not mean it is legally obligatory. In other words, legal positivists, those who have insisted that the demarcation problem can be solved, are keen to emphasize that, as I'll put it in what follows, legality does not entail morality, and conversely, that morality does not entail legality. You will notice, of course, that the need to draw this distinction to solve the demarcation problem turns on the assumption that the moral validity of a norm entails a practical consequence. That is, it entails acting in accordance with the norm. If we grant that assumption, then confusing law and morality has serious practical consequences indeed. It means that if the legal validity of a norm is equivalent to its moral validity, then, among other things, every law ought to be obeyed. And conversely, it means that if a norm is morally valid, then a legal actor ought to apply it, regardless of whether it's legally valid. The demarcation problem in philosophy of science was meant to solve a normative problem about theoretical rationality, about what we ought to believe. But as Loudon correctly observed, its solution had consequences for practical reason, for what ought to be done. And it was these that motivated the ultimately futile search for a theoretical shortcut. The demarcation problem in jurisprudence also purports to resolve a theoretical dilemma, what to believe about the nature of law. But the connection of an answer to this question to matters of practical import is even more apparent. We can perhaps diffuse the demarcation problem in jurisprudence if we tackle its underlying assumption, namely that the moral validity of a norm is overriding in practical reasoning. Suppose it were agreed that the moral validity of a norm was not overriding in practical reasoning. Suppose morally valid norms merely give defeasible, even easily defeasible, reasons for acting, just like legally valid norms and norms of instrumental rationality. That a norm was legally valid might, in some cases, also mean it is morally valid, but what if that did not change one's reasoning about what ought to be done? That a norm was morally valid might be an interesting fact for a judge to note, but it would not require from the judge one decision rather than another. In such a world, would solving the demarcation problem in jurisprudence matter? It's hard to see why. Kelsen and Hart, as everyone knows, were both metaphysical anti-realists about moral norms. That is, they denied that such norms had any objective existence. They denied that the best metaphysical account of what the world contains would include facts about what is morally right and wrong. This might suggest that the normativity of morals, its ability to give people reasons to act, should be understood in exclusively psychological terms. That is, as a psychological fact about what particular people believe and feel when they learn that it is morally wrong to do X or it is morally right to Y. Hart, in fact, accepted something like this view, I think, since unlike Kelsen's, his was an impure theory of law in which anti-realism about norms was conjoined with a particular form of non-cognitivism about the semantics of moral judgment, normative judgment. That is, to judge that doing X is morally or legally wrong is just to express a certain kind of attitude or feeling, presumably one tied psychologically to motivation and action. Insofar as Hart believed, quite reasonably, that people thought moral rightness demanded action in conformity with what was morally right, he had good reason to worry about the demarcation problem. The purity of Kelsen's theory, his reluctance to assimilate the normativity of law to psychosocial facts about behavior and attitudes, might seem to block the naturalization of the problem suggested by Hart's approach. I am afraid I'm with Hume, Nietzsche, and Hart in being skeptical that any sense can be given to the neo-Kantian idea of the grounds of intelligibility of the application of norms apart from a psychological one. I am also fairly confident, contra Quine and his retrograde psychological behaviorism, that our best theory of the world will, as Quine would say, quantify over mental states and over persons, but it will not quantify over moral norms. And so we need to approach the demarcation problem in that spirit. If we understand the idea of the morally obligatory or morally attractive in purely psychologistic terms, which is precisely how Hart should and perhaps does understand them, then the practical import of solving the demarcation problem changes. What is legally valid is not necessarily morally obligatory, and what is morally attractive is not necessarily legally obligatory. Those are the two key contentions of proponents of the positivist answer to the demarcation problem. But this only seems important to emphasize because people actually think the moral is overriding in practical reasoning. In a world in which people, for example, viewed moral obligation as on a par in practical reasoning with would feel pleasant, right, which could be a consideration in practical reasoning, in such a world it is hard to see why the demarcation problem would matter. Perhaps legal norms are morally obligatory, but that does not answer the question what should be done. And perhaps certain norms are morally attractive, that does not decide at all the question whether a judge should apply them. Admittedly, the world as the moral philosophers imagine it is one in which morality is overriding in practical reason. We may bracket for the moment Nietzschean or Thucydidean skepticism about whether this is the real world. The point that bears emphasizing is that the solution to the demarcation problem is supposed to answer a practical question about what ought to be done, one that is reducible to a psychosocial question about the attitudes people have about morality and legality. Thus, we may ask whether there is any reason to think a theoretical solution to the demarcation problem in jurisprudence will affect the actual psychological attitudes of persons. Defenders of legal positivism, the dominant answer to the demarcation problem in the last 200 years, are surely familiar with the contention that a solution to the demarcation problem has far-reaching consequences for practice. This was, after all, the central thought behind Lon Fuller's famous 1957 attack on H.L.A. Hart, which has been a target of philosophical derision ever since for its odd mischaracterizations of the claims of legal positivists, including Hart. Fuller thought, just to remind you, that the blame for the moral depravity of Nazi judges could be laid at the door of their positivism. That is, their view that they were bound to apply the legally valid norms of their immoral system. According to Fuller, positivism's definitions of what law really is are not mere images of some datum of experience, but direct posts for the application of human energy, direction posts for the application of human energy. And Fuller reminds us that, quote, words have a powerful effect on human attitudes. Thus, Fuller deems it worth asking, and I quote, whether legal positivism as practiced and preached in Germany had or could have had any causal connection with Hitler's ascent to power. Right? He puts it misleadingly there because, of course, that way of putting it, the answer has to be yes. Right? I mean, anything had or could have had, right, an impact on Hitler's rise to power. He intends a very particular answer, right, which is yes, it did. And he concludes that due to the ideas of legal positivism, the German lawyer, and I'm quoting again, the German lawyer was therefore peculiarly prepared to accept as law anything that called itself by that name, even, of course, when the law was morally abhorrent. Fuller's attack has been criticized for its misstatements of Hart's views, such as claiming that Hart believes there is, quote, an amoral datum called law which has the peculiar quality of creating a moral duty to obey it. That Hart's version of the positivist theory of law had none of the implications that Fuller claimed is not the issue. What requires notice is that the main practical rationale for solving the demarcation problem that we have identified appears to be the mirror image of Fuller's attack on positivism, namely that the correct or incorrect view about legality will affect action. To be sure, many legal philosophers might object that their only concern is a theoretical one, namely figuring out what is true about law. But we have never found any truths about any artifact concepts that would satisfy the desiderata legal philosophers like Raz and Dixon and Shapiro regularly announce, so it is hard to take seriously the idea that there is a theoretical reason for solving the demarcation problem. That leaves us then only with the practical reasons, and they are real enough, assuming one thinks that confusions about morality and legality have consequences in political practice. Let us suppose that they do, much as Fuller did. But why then think that a jurisprudential solution to the demarcation problem would resolve the practical conundrum? That's the key question. If I am right about the practical reason for solving the demarcation problem in jurisprudence, then positivism confronts a psychosocial phenomenon. People think or believe or feel that morally obligatory means overriding in practical reasoning, and they think or believe or feel that legally valid means morally obligatory. Does anyone seriously believe Kelson's pure theory of law or Hart's the concept of law are the political manifestos to counteract these psychosocial phenomena? To think so would be to commit Fuller's mistake, but in reverse. Fuller sought to lay at the door of Hart's positivism the reprehensible behavior of Nazi legal officials. A positivist solution to the demarcation problem would, by contrast, teach the Nazis that legal obligations are defeasible, since they are not moral obligations. Should one really think that Nazi officials would have acknowledged the force of moral norms that would defeat the legal ones? If Fuller was mistaken, not only in his characterization of positivism, but in his claim that it had some causal connection with Hitler's ascent to power, that's Fuller's words, then why should there be any practical reason to try to solve the demarcation problem in jurisprudence? Law and morality, as we noticed at the start, are pervasive normative phenomena in modern societies. We generally believe that judges have a defeasible obligation to apply the law. We also generally believe that judges, like other persons, ought to do what is morally right. These two normative demands can conflict, and then there can be hard practical questions to answer. The idea that a putative solution to the demarcation problem gives us the answer, which seems to be what Fullerians and anti-Fullerians think, is, I would suggest, an illusion. Even though we cannot demarcate science and non-science, we still need to assign degrees of epistemic credence to differing claims about what the world is like. And even if we cannot precisely demarcate law and morals, we still need to decide what it is we ought to do and what it is we have an obligation to do. Solutions to demarcation problems, if they worked, would give us shortcuts. But if they do not work, then we have to tackle the practical questions directly. In philosophy of science, that has meant concentrated attention on the epistemology of the various sciences, from physics to biology to psychology, and whether their distinctive claims are well supported by the available evidence. In philosophy of law, that would mean focusing on particular legal systems and the practical demands they make upon officials. To take a very American example, the question is not whether the original public meaning of the Constitution is the criterion of legal validity in the U.S. legal system, as, for example, the far-right Supreme Court Justice Antonin Scalia believes. The question is whether applying the original public meaning in resolving concrete controversies could be morally justified. Even if Justice Scalia were right about the legal meaning of the Constitution, the right conclusion might be that the legal meaning should be discounted. Now, some might wonder whether this posture has brought me surprisingly close to the position of Ronald Dworkin in his recent work, which would be a very bad thing from my point of view. For has not Dworkin chastised legal positivists for attempting to divorce legal philosophy from political philosophy, to divorce questions about what the law is from questions about what it ought to be and what judges ought to do? Indeed, he has, but for reasons wholly unrelated to the considerations adduced here. Dworkin thinks that solving the demarcation problem leads to answers to the practical questions, that the two kinds of questions stand and fall together. Thus, Dworkin claims that the positivist solution to the demarcation problem entails claims about how judges should decide particular cases. Though, as I and others have noted, this reading involves such a wild fabrication of Hart's position that Fuller looks like a paragon of interpretive charity by comparison. For positivists, the fact that a norm is legally valid certainly creates a prima facie legal reason to decide in accordance with the legal norm, but one that is defeasible by other equitable considerations. And conversely, Dworkin thinks his own theory of law's integrity both solves, or should we say dissolves, the demarcation problem, and tells judges how to decide concrete cases. The skeptical argument developed here is different. It suggests we abandon the demarcation problem in favor of arguing about what ought to be done, whether by judges confronted with novel cases or citizens confronted with morally objectionable laws, on the grounds that human artifacts never admit of successful analysis in terms of their essential characteristics. The inductive lesson to be learned from 20th century philosophy, especially philosophy of science. The lesson, frankly, seems well confirmed by the increasingly Baroque attempts by legal positivists to solve the demarcation problem after the valiant and seminal efforts of Kelsen, Hart, and Raz. And it seems equally well confirmed by the efforts of natural law theorists like John Finnis and Mark Murphy, who really want theorists to focus on morally good law, or practically reasonable legal systems, but who insist on claiming that their transparent change of the subject is really an answer to the demarcation problem, really a case of saying what non-defective law is or what the focal cases of law are, and you could pick their other favorite metaphors in this context. The professionalization of philosophy, including legal philosophy, guarantees, I fear, continued attention to the demarcation problem, since specialization always runs the risk of generating both an audience and performers for ultimately pointless disputes. In the spirit of Marx's second thesis on Feuerbach, let me suggest that a dispute that is isolated from practice is a purely scholastic question. I can see why Kelsen, Hart, and Raz might have thought that a solution to the demarcation problem was both possible and might be relevant to practice. I think we no longer have an excuse for believing this today. Thank you.
Terrific paper. We will open the session for discussions. We have 45 minutes. Okay, so we will start with the individual there, then Scott, and then Robert. Oh, yourself, yes.
So this is a great paper. I have a question. It's probably a clarificatory question. And it's a puzzle on 16. At the final paragraph of 16. And it strikes me that you might you'd have reintroduced a motivation for the demarcation problem, or for the importance of solving the demarcation problem.
Can I just ask Stefan, is that law and morality are pervasive normative phenomena in modern societies?
Yeah.
Okay,
Yeah.
go ahead.
Yeah, they're
because I have different pagination, that's why I'm asking.
Oh, okay. All right. Yeah, so they're at the bottom. Because you say, on the one hand, we generally believe that judges have a defeasible obligation to apply the law. We also generally believe that judges, like other persons, ought to do what is morally right. And the idea is that these things can conflict, and we need to, do what we ought to do in these cases, and we have to adjudicate this conflict. But that seems to suggest what we really need to know what the law is, and we really need to know what the moral obligations are. And if we want to have a hope of adjudicating the conflict, it'd be nice to know the relationship between the stuff that's the law and the stuff that's morality, if there is any relationship.
Okay, so I think it's a mistake to think that we can't have a rough and ready and intuitive distinction between categories in the absence of an analysis of what marks the distinction in terms of essential and necessary properties, right? So we clearly have the intuitive distinction. Sometimes we're very comfortable with it. It's manifest in ordinary language. The only thing I want to suggest in this paragraph is why not just ask the question, what ought to be done, right? Rather than thinking we can first answer the demarcation problem question, which will then in turn give us precise answers to what ought to be done, depending on what we think about the solution to the demarcation problem is, and depending on what we think about the nature of moral reasons. So that's why I don't think this kind of observation or any of the references to law and morality, as it were, immediately open the door back up to the original problem.
Scott, then Rob.
Hello? It occurs to me now this is our second meta debate. First we had a debate about the Hart-Dworkin debate. Now there's a debate about the demarcation debate. So either we're doing something right or wrong. I don't know. Right. I'm not going to try to refute the skepticism. I just want to kind of complicate it a bit by just noting an ambiguity about the notion of an artifact concept. So on one hand, it may be the concept of a human creation that is a concept whose extension has been created. Everyone, I imagine, believes that is laws of human creation. But the second sense of an artifact concept, which is a concept whose extension is defined by the purposes of those who created it. Now, and so lots of people say, about, clocks, a clock is something we just created in order to tell time. But I don't think, I don't know of anyone who actually thinks that the law is an artifact concept in that second sense. That is, they don't think that what individuates the law is that it was created for a certain purpose. What they think is something close to it, but importantly different. That is, it's an artifact that was which has associated with it certain claims of purpose. Okay, so it's not why they created it, but what they claim about it. That is, it's there to solve certain kind of moral problems, or to mediate between reasons and persons, or to engage in social coordination or something like that. Now, if that's indeed the case, one of this kind of the skepticism that one would have about law, that is, that could be millions of different reasons why legal systems are created and sustained, would not be a ground for skepticism, because it's not individuated in that way. It's individuated by the claim. And if it were true that the claims were uniform across all possible and actual legal systems, and that would be a way to demarcate law from non-law. Now, of course, this doesn't show that it can be done. It just shows that what we mean by an artifact concept, there's some slippage here, and so I just kind of want to flag that important.
Let me just ask you one follow-up question before I answer your question. What do you take to be the grounds of ascription of the claims by which the law is individuated?
Oh, well, I mean, people have different theories of that. So it could be that normative language is used. It could be the particular content of a legal system, the kind of problems that they address. It may be that they're, legal officials wear funny clothes and they, speak in funny ways, and they congregate in temple-looking like structures when they render judgment. So there are many different kinds of theories about the laws, how the law claims anything. But the point is, it's the claim, not the actual intentions of the participants, which is supposed to do the individuation.
Okay, good. Thanks, Scott. That was a very nice question from one of the leading defenders of an answer to the demarcation problem. So I appreciate that. I think this question actually trades on some misunderstanding about artifacts, or at least what I meant by artifacts. So I don't take it to be the case that what's distinctive of artifacts, right, is that their nature is fixed by the intentions of their creators, right? The claim, sometimes they are, right? Sometimes they are. I take the important claim about artifacts to be is that they are, and this is why I use this phrase in the paper, hostage to human ends and purposes, which may or may not be the human ends or purposes of their creators, right? Which often happens, of course, when artifacts have very long histories and go through changes over time. So that's the funny feature of artifacts, is that they're hostage to and responsive to human ends and purposes, which is probably precisely why we have so many different theories about how the claims, right, the claims of law, say, are to be individuated, or why there can be so many different views about what the nature of a chair is, depending on the particular cultural or local role that chairs play in human affairs. So nothing turns in this on artifacts being identified by the intentions of their creators. If you grant that artifacts are hostage to human ends and purposes, and you grant that human ends and purposes change, right? Maybe we will come to a point when they don't, right? Then it would be very surprising if it turned out that there were essential and necessary features for anything to be the particular artifact that it is. And in that regard, it's different than natural kind concepts, which I take not to be hostage to human ends and purposes in the way that the things picked out by artifact concepts are.
Robert, please.
Yes. Yes, thank you very much for your highly interesting lesson. And you talk about, at page 18, about the midst of the page.
Yeah.
You are talking about the lesson to be learned from 20th century philosophy, especially philosophy of science. We learn something in philosophy. Do you really think that one can learn from the philosophy from a century, and because the century is over, all these things are old, why then do you make recourse to Nietzsche? It is 19th century, even older, and David Hume, as you do.
They were very smart.
Okay. But why do we not say, for instance, that's my first point. I think it is rather strange to say in philosophy that we have now and forever learned something, for instance, that only, as you put it, perhaps at page 13, something like a psychological approach that is to propose an ontology which recurs to what Popper or Frege has qualified as the second word. And that's my question. Do you, that is a second word according to Popper or Frege. And I ask at the same second, do you think that Frege not is, but has been proven to be wrong, to believe in German it is der Gedanke, the thought, perhaps in English the translation, yes? That when she says in the thought, yes, it was before the Third Reich, ein drittes Reich muss anerkannt, a third imperium must be recognized, and that is the imperium of the spirit. Well, that is my first remark. You have here a very, very extremely strong metaphysical thesis that the third word does not exist, the word of meaning. My second point. You say at page 17, you identify the decisive question, and my argument now is that your question leads into the third word that means in the word of meaning contents and something like this. It is line 4 from the top. What it is we ought to do and what it is we have an obligation to you. There are questions which ask for reasons. And now I would like to hear from you. When you remain in the world of psychological, social psychological fact, how to produce reasons from that material? That is my question. A third remark, the demarcation problem. Well, the positivists always thought about this problem, but the counterposition was the connection problem. And how to connect law with morality. And that you have some formula. If something is legally valid, then it is morally valid. I think no rational non-positivist ever had adhered to such things. He says sometimes moral defect can undermine legal validity. Not more, not less. For instance, the Radbruch formula. That is, I think that you construct the demarcation problem in a way that it must be nonsense to ask this question. But we can formulate the question concerning the relation of morality and law in a way that comes not up to these points you make. I think our time is scarce, and therefore I must close in spite of the fact I would like to ask further questions.
Okay. As long as you don't attack me afterwards. Let's see. So did 20th century philosophy of science establish that we can't solve the demarcation problem? Well, what I strictly said is that it's very hard to ever establish that it cannot be solved, right? What it left us with is the widely shared sense among philosophers of science. I can think of only one exception. Well, sorry, two if you count some of the mad Popperians in London, but left us with the sense that we were not able to solve it. So what I'd have to hear in response is what you think the demarcation criterion is for demarcating science from non-science, and then I would get worried that we've drawn the wrong lesson from 20th century philosophy of science. In the absence of some affirmative argument about what the demarcation criterion is, I'm inclined to think that we drew the right lesson. And it's a lesson that largely philosophers of science, as I say, have accepted. That is, a lot of the 20th century was devoted to this debate, and it essentially hit a stalemate. And the Loudon paper does a nice job of, I think, capturing what the current wisdom is. But I'm a fallibilist. I'm as much of a fallibilist as the next empiricist, so it could turn out that's wrong, right? But given that that we don't have a very good track record of giving essentialist accounts of any artifact concepts, I'm inclined to think that probably this is not going to be turning out to be the wrong moral to draw. I think I didn't entirely understand where the reference to Frege came in, but let me speak to the part which I think I did understand, which is it's certainly not my view that meanings don't exist, right? This is part of the reason for the parenthetical aside about Quine and his retrograde behaviorism. I mean, it seems to me that we're entitled to assume whatever exists that's necessary in order to successfully explain the various phenomena we can observe. And it seems to me, 40, 50 years after the demise of behaviorism, with the cognitive revolution in psychology, there's simply no way around the fact that meanings are among the entities we have to posit in order to explain certain kinds of observable phenomena. So I'm not a meaning skeptic. If I said something in the paper that made me out to be a meaning skeptic, someone should point it out to me so I can pull it out of there. I don't know if that fully gets to what you were after about the Frege comment, but that's what I took away from that. Now, reasons. So what does it, if I say the question is, what is it we ought to do, right? What reasons are there to do one thing or another? What is the status of reasons on an essentially psychologistic, naturalized conception of norms? And I think the answer to that is that reasons, right, are just the kinds of considerations that are able to produce some kind of motivational response in persons. Right? And there's nothing more to it than that. That, of course, is going to lead to certain kinds of problems in distinguishing, right, between the mere causes, our ability to cause people to do things versus they're doing it because there's what we would call a good reason to do it. I happen to think it's actually, that's a problem we have to live with because I don't see any other intelligible way to think of reasons. So.
Okay, thank you. Please. The gentleman here, yes. No, sorry. First, the person just, yes. Thank you. Yeah.
In support of your claim that emphasis on the demarcation problem is motivated, at least partially, by practical concerns, you offer a thought experiment, right? If people didn't think that morality or moral considerations were overriding, we wouldn't care so much about the demarcation problem. I worry about this strategy, this argumentative strategy, because it seems maybe it might commit you to this overarching pragmatism that you might not want to accept. And just to give you an example of what I have in mind, if this is true of legal theory, it might be true across the board, right? John Searle uses this thought experiment. He says, imagine if we were a society which whose main goal was to glorify God by means of making thump-thump noises, then our biologists, if we had biologists in that society, would assign to the heart the function of glorifying God and not the function of pumping blood and so on. So if you tweak just enough when our beliefs with regard to morality and so on, you'd change pretty much everything, right?
Right. So let me, I think you're locating the place of that consideration in the wrong piece of the argument, right? So you're right that I was using that to suggest why we might think solving the demarcation problem matters, right? But of course, we don't live in the world where this is the morally right thing to do has the same normative status as would feel pleasant. We live in this world, and we don't live in the thump-thump heart world, right? And so then I move to the question, well, what does it mean, right, to say there's this question about what should we do when something is the morally right thing to do? And then I suggest a psychologistic interpretation of what's going on in those cases. And then I raise the question, right, should we think a solution to the demarcation problem is going to be an adequate response to what's essentially a psychosocial fact about what people believe, their attitudes, their motivations, and so on. So I wasn't endorsing that example as a general, right, in order to support a conclusion that we don't need to solve the demarcation problem because we might have lived in a world, right, in which the morally right thing to do didn't have any special status in practical reasoning. That doesn't appear to be our world, or at least it doesn't appear to be the world of the moral philosophers. As I alluded at one point, in reality, it's not entirely clear that people think moral reasons are overriding in practical reasoning, judging from the things they actually do.
Lady, please.
My question is actually tightly connected to what you were just commenting. It also seems to me that you agree with the underlying assumption that you're formulating, that moral validity entails action according to the norm. And I'm actually more preoccupied how this what could be its effect on other work that you're doing. And I'm specifically thinking at judicial practice. And what would be, if you accept this assumption, what would be its implication in judicial decision-making?
The assumption that the moral validity of a norm gives an overriding reason for acting, for how one ought to act.
Upon the judge. And
yeah.
What weight would would the moral consideration have as opposed to other considerations?
Yeah. You see, I'm not entirely sure that's a question for me as much as it is for those who think a solution to the demarcation problem would make a difference to practice, right? Because, so if we accept that moral reasons are overriding in practical reasoning, right, then whenever a judge has a moral reason to do something, that's what the judge ought to do, quite regardless of what the law is. And that was part of the conclusion, right? One of the consequences, I take it, we were trying to resist here. There can be circumstances where moral reasons override legal reasons, but I'm not sure anyone wants to endorse the general principle, not even I think John Finnis, that moral reasons should always override legal reasons. My alternative question is we ought to ask the question, what ought to be done, right? And not ask the question whether or not the norms in question, right, are legally valid, merely legally valid, or morally valid. Now, I actually happen to think that moral reasons shouldn't be overriding in practical reasoning, but that's a slightly different consideration. So.
Okay, I see two problems in your presentation, a philological problem and a consistency problem. Philological problem, well, maybe Hart didn't tackle with what you call the demarcation problem in that way, and he did not look for necessary and essential condition of law, but actually he proposed a definition of a municipal law central case by pragmatic case. So, but that's one point. Consistency problem. It seems there is a jump in your presentation because you offer convincing arguments to get rid of a demarcation problem as it was traditionally conceived. That means finding out necessary and essential properties distinguishing the law from morality. But then, and you say that, and then you seem to jump to the conclusion that we should get rid of a demarcation problem in any sense. Then you say what is important is what we have to do. But for answering to this question, we need to demarcate between law and morality somehow. Of course, maybe not in the ambitious way of the past, but in a less ambitious, more pragmatic way. Thanks.
Okay, thank you. Yeah, so on the question of what Hart thought, I mean, of course, when he characterizes the conditions for the existence of a legal system and the concept of law, he does in fact use the phrase, right, these are the necessary and sufficient conditions. He does talk about trying to figure out the essence or nature of law. Perhaps if he had been more thoroughgoingly Wittgensteinian, he would have avoided, right, that language, and then might be able to dodge this this line of criticism. Of course, later writers who have been more self-conscious about the methodological issues, including Raz, including Shapiro, pretty clearly bite the bullet on the view that I'm raising some doubts about. Now, on the consistency. See, I take this in a way to be a variation on Stefan's earlier question. Here's a simple way to put it. It's a non sequitur, I think, to say that because we cannot demarcate two categories in terms of essential and necessary attributes, that there aren't particular contexts where we can demarcate them quite satisfactorily, right? Those were the cases I was referring to earlier that seem like, you know, reasonably intuitive cases, right? Where we can say that, you know, in the United States, it's now illegal for a state to sentence a juvenile to prison for their entire life if they haven't murdered someone. That's clearly the law now. There was just a Supreme Court decision on that last week. It would be morally good if, let's say we're Peter Singer, it would be morally good if people gave a certain portion of their income to charity, right? That's not the law in the United States, but maybe that's a good interpretation of morally what we ought to do. So the fact that we have rough and ready intuitive distinctions doesn't go out the window here, right? The problem cases come right where we get into the borderline area where the borderline of the morality and the legal is less clear, and then the thought is a solution to the demarcation problem would actually resolve the practical dilemma, right? By telling us what the status of the norms is. Either they're morally valid or they're legally valid, right? And all I'm saying is, why not just ask the question, forget about the demarcation problem, and just ask the question, what ought to be done, by reference to any set of considerations that bear on what ought to be done, which might include some that we can identify as legal, some that we can identify as moral in this fuzzy everyday sense that works reasonably well, but not think the demarcation problem solution is what we need in order to answer those practical questions.
Okay. I think I guess I want to push you a little more on what is doing it right. Again, what do you want? What would the version of the right way to do it go? Because perhaps this is because I am the sort of overarching pragmatism that was pushed earlier as a bad thing to stay away from. I think that would actually entail a fair amount of thinking that involves categories and ruling in and out considerations based on which category they're part of. And I think most people experience themselves to be part of different traditions or communities or religions or ethnicities that bear on what's to do precisely because these considerations emerge from the tradition. People think that because I am a Catholic or a member of this university community, I have a reason to do this thing. And I guess some of these authors, Raz in particular, it strikes me, are coming at a perspective that seems quite fruitful, that I guess I'm in sympathy with Coleman's paper from this morning, where it was saying that his whole position is starting from an idea that perhaps partly it's a terminological problem. He seems to use, as I've always thought, that he uses morality simply to mean the correct view of what's to be done, all things considered. And so the question is, well, how do state acts influence these considerations? And most of his work by pages is about trying to elucidate these things, the way in which it does and doesn't affect these things, rather than simply saying there are these two bodies that are both subsets of what ought to be done, and we compare them. It's about making practical reasoning in a fairly comprehensive way, about saying we have to, as limited people with limited cognitive abilities, use these shortcuts for practical reasoning to one degree or another. You're saying you think that decisions need to be somewhat case by case, that, well, what does it mean for this law, that we should acknowledge these hard practical decisions, but legal systems are bureaucracies that have to be institutionalized to some degree. So, I mean, the legal system has to be able to have some degree of general rules for deciding which considerations are in and out, and which then bear on particular disputes. And that's the degree to which it seems like you need inevitably to have a way of solving the demarcation problem. So I guess I'm just wondering how is your position hostile to this idea of a fairly straightforwardly instrumentalist motivation for solving it that I see in Raz even, and that I thought I saw in Coleman's interpretation of Raz in this morning's paper.
I was with you on a lot of that until the inevitably. So a couple things. So Raz, of course, is a full-blown normative and moral realist, right? He didn't learn his metaethics from heart. But at the same time, right, Raz doesn't think that moral validity is a condition of legal validity. It is certainly true that a lot of his work is given over to questions about what ought to be done, right, how society should be structured, and so on. But those are, for him, genuinely separate questions, I take it, from his views about the nature of law. Now, so let's just put the Raz to one side for a minute. Let me go back to make clear what I was thinking, go back to the example I gave in the paper, right? So here's this question that comes up in American constitutional law. So Justice Scalia is the primary advocate of the view that the original public meaning of the Constitution, the original public meaning of the text at the time it was adopted, and let's assume, contrary to my Genoa friends, that there is such a meaning. He clearly assumes, right, that there is such a meaning, that is what fixes, that's the relevant criterion of constitutional validity. Now, we could argue about whether or not, right, he's got the right criterion of constitutional validity, right? Or we could just argue about whether the original public meaning of the Constitution ought to be binding on courts in reasoning about what ought to be done. And if we go straight at the second question, then we're not going to worry about issues that are resolved by the demarcation problem. We're going to worry about questions like, was the original public meaning of the Constitution one that would have any moral claim to be binding on us 200 years later? What kind of results would it lead to? Would it in fact be welfare enhancing, right? Would it maximize well-being? Those would be the kinds of questions we would actually ask, rather than appealing to some view about the relevant demarcation criterion to say, well, yes, he's either right that it's legally binding, or no, he's wrong. So.
I will be grateful if we are very brief, because we have still 4 people who would like to ask questions, and we have only 10 minutes. So.
Okay. Maybe I'm going to raise a merely verbal question, the issues. That's possible, I don't know. But I'm just wondering, is Brian confusing two independent issues? Because you begin by the demarcation problem, properly understood, and then you shift to the connection, to law and morality connection, if any, problem. Now, the demarcation problem, as I understand it, and the analogy with the demarcation problem in philosophy of science suggests this is distinguishing law and non-law. For example, remember the classical question whether the international normative system is a legal system or not.
Right.
But this is quite different from deciding whether we should adopt a concept of law, an evaluative or a merely descriptive concept of law. I cannot see the connection between the... Huh?
Okay, I agree with you, those are quite different, but the second one wasn't what I was advocating, right? So this wasn't an argument for saying, let's adopt a conception of law based on its practical consequences, which Schauer has said, Liam Murphy, and other people say. So that wasn't the view I was arguing for at all. So I would agree with you, that would confuse things. Therefore, I think Brian didn't confuse things. I hope.
Luis, please.
Thank you. Well, if I understood you properly, you identify and reject two claims which you say underlie the traditional discussions of the demarcation problem. One is the claim that the problem can be solved. The other is the claim that the problem, that solutions to the problem matter in your expression. Your counterclaim to the first one is grounded, as you say, on the skeptical induction from past failure. I'd like to concentrate on the second. I think that to formulate this as the claim that a solution to the demarcation problem matters is perhaps excessively general. You yourself seem to grant that a solution would be practically relevant when you say on page 17 that solutions to demarcation problems, if they work, would give us shortcuts, and this is, in a sense, a practical difference. So you need a stronger formulation than that, but not a formulation so strong that it would be implausible to attribute it to tradition. I think no one would defend, as you suggest on page 16, that a solution to the demarcation problem would give us the answer to hard practical problems. So this would be too strong a version. My question is, could you please formulate it in a more precise manner?
Okay, so let's see. The first formulation, which I think did come from the paper, right? That it gives us a shortcut. I don't see as inconsistent with the tradition, and you weren't saying it was. Okay, I agree with you that the second one you referred to, right, does seem too strong, at least if we want to ascribe it to any particular individual as being committed to it. So let me say at least part of what I was doing here was trying to ask the question, right, why might we think it matters, right? And one reason we might think it matters is that it either gives a shortcut or it in fact gives the clear answer to certain kinds of hard questions. I take it most of those who've been interested in the demarcation problem, right, while the practical interest is often, it crops up or it's beneath the surface very often, primarily they present it as an inquiry in theoretical rationality about what we ought to believe that's true. So to that extent, it's, I'm ascribing rather than describing something for which I can give you good textual evidence. Now, what do I think is the right formulation? I guess the shortcut version is going to be closer to it, but I'm going to have to think about the right way to put that so as not to overstate it in a way that makes it too easy for people committed to the pointless dispute to continue with it. So that's a fair question. Thank you.
Is you, what you said about human artifacts. It is probably impossible, or at least very difficult, to find a set of necessary or essential conditions. But why should we pose the question of the demarcation problem in terms of essential or necessary conditions? We could proceed another way, just find certain clear cases of science, like mathematics or astronomy or something like that, clear cases of that is not science, or it perhaps pretends to be science but is not, like astrology. And there are some cases which are doubtful, probably penumbra cases like perhaps legal science is not very clearly science in the same sense in which mathematics or physics are sciences. And this could give us a clue to some sort of demarcation, not necessarily in terms of necessary and or essential conditions.
Good, thank you. So two considerations. First, the targets of the critique here, I think, are committed to the stronger claim about essential and necessary conditions. So what we ought to come back then and say is, well, they ought to ratchet down their ambitions, right? Why not settle for something like the method of clearer paradigm cases and then by analogy to the other cases? The reason I think that's probably not going to do the trick is because it's going to mean the demarcation criterion doesn't demarcate in precisely a lot of the cases that people are very upset about, right, and very, very concerned about. I mean, the nice thing about necessary and essential conditions when they can be found is they make it determinate, right, whether or not something is an instance of X or not, okay? And the difficulty from this standpoint with the method of clearer paradigm cases and then analogy, something, Wittgensteinian family resemblance or something like that, which I think actually works pretty well for what I've been calling the sort of mundane intuitive distinction that we work with, but it falls apart, right, in some of the very hardest cases. And then someone who was really a proponent of the solution to the demarcation problem would say, aha, well, I've got a solution, and so I can actually deal with those cases as well. So, but I'm in a way sympathetic to that as a better way of thinking about it for most mundane purposes.
Torben, yes, the last question.
You hear me? Oh, good, yeah.
Indeed.
Okay, I would like to connect to the two questions before Professor Bolig. And so my concern is that possibly you're asking, too much of the dispute. Why does it matter to be of practical relevance? My first question is, I take it that covers the fairly common claim that, let's say, that positivists maintain that a positivist concept of law is conducive to clarity, intellectual clarity, and things like that. But if it covers that, how do you feel about the claim made by both Ross and Alexei that an inquiry into the nature of law will likely contribute to our self-understanding? How do you... I can't say that I find that, I mean, I'm not sure what it would be. What do you think? I guess you don't think so.
I'm not sure I have a view on that one way or the other, and I don't think the argument here actually commits me to a view on that. So it's certainly true that the practical relevance I was focused on, which I think really does animate the interest in the demarcation problem, has to do with the question what ought to be done, in particular by legal officials in certain circumstances. I'm happy to think that law, like every other hermeneutic concept that people use to make sense of themselves in their social world, that it might be practically useful, right, to think about law for that reason. I will say, perhaps somewhat uncharitably, I've never met an ordinary human being whose understanding themselves had been helped by Raz, but it's certainly in principle possible. But I wouldn't stake my defense of the significance of Raz's work on its having that particular effect. So.
Thank you, Brian, for this terrific paper.
Thank you.